the other side of you.
Yeah. It's mirrored.
Ew.
Like if I share that view, you do. That's crazy. Stop sharing. Oh. This is ridiculous. Stop sharing.
So that works.
Yeah, but when your friend Teams is in,
It's not.
I don't know how.
So it's
This is
5:35
gonna
now.
go.
He's supposed to be calling.
Can you tell him to join? We're gonna go.
He can call in, but it's 5:37. I don't know if he's having trouble.
He accepted my meeting request, so. Oh, he's calling in.
Oh, yeah.
Hi.
Hey! Can you hear it? Can you hear us okay?
Yes,
yeah, just
we
fine.
can.
Thanks, John. We're going to get started in just a minute. We're, per usual,
Having
It
tech
would-
issues.
it wouldn't be a STEP class without some kind of tech issue. But you're in here. We can see you just fine. Nice and crystal clear.
I'm sharing a screen through Teams right now. Do you see it? The PowerPoint?
Oh wow! And do you see yourself like in the corner? Like, oh wow. Okay. Well, all right.
It's
Now
we're having issues on our end.
Can you still hear us, John? Okay. All right. Well,
But they won't be able to see him.
that's okay.
I'm gonna go.
I can see myself. Tori's gonna log in, and see what she sees on her end. But we'll just go ahead and get started. And you know, the issues are what they are, and we can always edit out, you know, some of this stuff going forward. But we're gonna go ahead and jump right in to the material. And so, hello, everybody. Welcome to STEP. I do apologize for the technical issues that we've been having. As I mentioned to my guest speaker this evening, it wouldn't be a STEP class without these issues. They seem to be plaguing us every class that we have. But thank you for your patience, for hanging in there with us. And for enjoying the material. I've certainly enjoyed presenting them to you. I've had some wonderful guests here that include our guest speaker this evening. And we've had guests from Community Health Law Project. Thank you to Sarah Webb, other attorneys from Legal Services of Northwest Jersey, including David Saltzman, Randy Yang. We've had some guests from the court, Christopher Witten, and you know, it's been really just a lovely experience to have everybody come in and provide their experience and share their story and give a little bit to the different topics that we've been doing. So for those of you joining us for the first time, this is what is called STEP. STEP is an acronym, STEPP. So STEP stands for Stabilizing Tenancy Eviction Prevention Program. So what is STEP? STEPP is a grant-funded program. It's a grant that comes from the New Jersey State Bar Foundation. So thank you to the NJSBF for your generous donation. And that allows us to present this material to you. So it allowed us to procure the technology that we are still struggling with, but it allowed us to, assemble the visual elements of it, and do all the great stuff that we're doing tonight. So the purpose of STEPP, Stabilizing Tenancy Eviction Prevention Program, is to set up a landlord-tenant course or series, the purpose of which is to inform the community so that we can go forward as a community and have more civilized, more peaceable landlord-tenant transactions, that tenants and landlords abound, both enjoy and understand and can assert their rights so that those transactions are smoother and more streamlined. So if landlords know the rights of their tenants, they can write leases and they can interact with their tenants accordingly. And same goes for their tenants. If there's an issue, they know what the law is and they know how they can assert their rights as tenants. But of course, if the matter does become litigious, we know that, through the information that you learned here, that you can definitely pursue these matters with the knowledge that you have. And one of the through lines that I always make sure that I communicate with these classes is communication, 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 and making sure that you seek that early representation. So as I've made known in other courses, your right to legal counsel, it does not constitutionally attach, or it's not constitutionally guaranteed in a civil trial as it is in a criminal trial. So we're all familiar with those cop shows where they're Mirandized and told, that if they cannot afford an attorney, one will be appointed to them. That is not true in landlord-tenant court, which is part of the civil division and the special civil part in Superior Court. And so always make sure. So one of the things, the through line here is no matter what you learn through this course, please make sure, and my guest speaker tonight, who I will introduce shortly, please make sure you reach out to him, his fellow colleagues at Legal Services of Northwest Jersey early so that they can give you that comprehensive legal representation. They can get a look at your case and help you early on. But of course, John, I'm going to go ahead and introduce you now. John, you are one of the, I think David had mentioned when he came on this program, you are one of the few legal services offices that will do live in-person intakes, like right there. Like, so if somebody hasn't already done an intake, like with your office, unless I'm mistaken and you want to just kind of fill me in here, but it sounds like you guys are there, one of the few offices that are there in court out of the 5 counties that Northwest Jersey, Legal Services of Northwest Jersey operates from, that you guys are one of the few, or maybe the exclusive office that goes to court with you have an interpreter, you have an intake, provider, you have a social service provider, and you guys will take clients in real time in court that approach you. Is that the case? Mm-hmm.
You are eligible for under those guidelines financially and you're a U.S. citizen, we would take your case right then and there.
Okay, that's excellent. That's excellent. And that's great to know because in my experience, so I am not a lawyer. I have some legal background educationally, but my job is as a social service provider. And so what I see in court is because the grant that I operate under and how we came to know each other is the CEDD grant. So that's another grant here at Family Promise of Sussex County for those watching and listening. Another really great grant that we have, it was from the New Jersey Department of Community Affairs. It allowed myself and my staff to go to court as resource navigators. And basically, we were just bridging the gap between the proceedings in the courtroom and the community services, or we tried to tap into our own funding or find funding elsewhere in the community. But the whole idea was to work with attorneys, work with court staff, work with landlords, work with tenants, other area service providers and try to help develop a resolution to the problem, whether that's to pay the rental arrears or try to find an underlying cause that we could provide services to. So if there was a crisis of faith, mental health, substance abuse, domestic violence, things like that, we could try to plug them into the services. But that's how we became in contact with each other, Jonathan. What I see in court, and kind of to the point that we've been talking about, what I used to see, and I do apologize, Tori's coming back and forth because she's trying to correct the tech issues. And I think I saw a little one kind of scurry past in the background.
Yeah, she just came home from school.
I do apologize, as you know, we're going through this. We're just trying to get some of this tech worked out, and I'm sorry about that, John. So John and I, for those who are watching the video, John and I came to know each other through our relationship. So he works for legal services. I work for Family Promise. And, we crossed paths because Family Promise would be there to try to help pay some of the cases where there was back rent owed. And then John and his wonderful team would try to identify some of the legal issues and try to, help their clients out. But a lot of times our services would overlap, because in order to get your client the dismissal that they needed, it would require money from this agency. But it was a really great collaborative working relationship. Thank you, Tori. So that looked a lot better, at least from our end. I can finally see what it is we are trying to talk about. So the lovely Tori, everybody.
Stop.
I think you accidentally muted John.
Oh.
Oh, no, I muted myself.
Oh, gotcha. Oh, okay. There we go.
Yeah, don't worry about it.
All right. So.
Okay, you're not going to be able to see us, but we can see you.
And I can change.
Looks good to me.
To change, you're going to go to here.
Okay.
And you're just going to.
Excellent. All right. Very good.
Yeah.
So I can just change them. Okay, wonderful. All right, let's get back on track here. So again, folks, I'm here with Jonathan Tolentino. He is our guest speaker for Course 8. So this is really exciting. I feel like I'm Matt Berry on college football final, and we were counting down the weeks. We're now in week 8, and this is a really, we're getting to the end of the season here. So we are almost towards bowl season. This is amazing. So we are now in Course 8. We started way back in September when we did housing discrimination, and I'm going to show you guys a quick timeline here, and a quick disclaimer. So, and this is how we start every class. So, again, this is an informational session. These classes are designed to provide and arm landlords, tenants, legal service providers, area practitioners, and anybody who wants to be part of the solution with the information that they need to have more civil, peaceable landlord-tenant transactions. But it's meant to be informational and informational only. John is here, and he is a barred licensed attorney. So if you do have any questions that are of legal consequence, and if he's capable of doing so and allowed to do so, he can answer those questions. But I legally cannot provide you with advice, nor can any representatives from Family Promise of Sussex County. We are a 501c3 nonprofit charitable organization. We deal with housing issues. So we do not, we help people who are either at risk of homelessness and divert that eviction or that homelessness, or people who are, plagued with the crisis of street homelessness, and we help rehouse them. But we are not a legal service provider, but we certainly would refer you to legal services if you had a legal issue. So we'll just get that disclaimer out of the way, and we'll go ahead and move forward. And here's the timeline I was referring to. So we started with housing discrimination way back in September, and it's still, it's still 70 degrees in November 5th, but we're doing property retrieval post-eviction today. So we've done the full gambit of different, topics, nuanced topics as they pertain to landlord-tenant law, housing discrimination, familiarizing yourself with the law, renting your new home, rent increases, habitability, lease termination, landlord rights and eviction. And now we are finally here November 5th at property retrieval post-eviction. And then after that, we'll have 2 more classes. Wrapping up on November 19th will be our last class. So we'll go ahead and proceed with the topics tonight. So again, today's guest speaker. So I'm your direct services or programs manager here at Family Promise. Jonathan Tolentino is an attorney with Legal Services of Northwest Jersey. He is our professional expert today. He is going to be giving us his insight as to the topic of we're going to be dealing with property retrieval post-eviction. I think that title is a little misleading. It's because we're not just dealing with property retrieval if you are evicted we're going to be talking about the abandoned tenant property statute, and basically running down the process of what happens when you leave the property that you were residing at, or the dwelling you were residing at, and you've left property behind, or you need to go back and get it. What's the proper way to go about getting it, and the steps, and what can your landlord do if you leave that property behind? Do they need to put you on notice? All of that good stuff. So we're going to walk through that with Jonathan right now. But as we bring Jonathan on board to talk about this material, right before we get into it, John, I wanted to ask you, how long have you been practicing law?
I've been practicing law. I graduated 2015, so almost a decade.
Wow.
I started out with community health law project initially, right out of law school, and pretty much the majority, well, all of my legal career, I've been in direct legal services. So I've been doing this type of work my entire career.
Wow.
And why? The main reason why is, as much as there is a right to legal counsel in a criminal sense, I think everyone deserves access to justice, defense, or plaintiff, if they can't afford it, in a civil sense as well. So,
Excellent.
and that kind of sense of need came from a clinic I did in law school, where we were providing, much like I am now, direct legal services in a civil sense for landlord-tenant, as well as Social Security benefits and consumer issues.
Oh, wow.
And I had
Okay.
a case, yeah. So I had a case that really stuck with me, with someone who was dealing with mental health and disabilities, and I felt that that was something that I wanted to do moving forward as a career, because I felt that that person really benefited from having that access to an attorney.
Excellent, excellent. And I do apologize. I actually said "wow" before, and I
Oh,
think it came off as like sharp, like "why." No, so I do apologize. But that's excellent, because I was going to ask you, and I meant to ask. So you got out of law school and you started with CHLP, and then you transitioned into legal services of Northwest Jersey, and you've landed yourself like dealing with a few things, and and I have to say, in the experience that I've had in being able to observe you and your colleagues in court, you guys have been absolutely exceptional and wonderful advocacy, and God bless you guys, and really, just do some wonderful work and advocacy on behalf of the clients who really absolutely need it. So it's so wonderful to have that service there, and we're all so grateful, and certainly grateful for your time here this evening. So thank you once again
oh,
for
thanks.
taking time out
Yeah.
of your busy evening.
Oh, no problem.
So we'll get cracking right into the material. John, can you tell the audience what exactly the abandoned tenant property statute is?
So the abandoned property tenant statute is basically a statute that was put in place for the sole purpose of being a protection for tenants, or for anyone who's leaving a property that they don't own, um, to protect their personal property that's left behind. A lot of the time, in an eviction kind of setting, things are moving very quickly, and tenants don't know where to go, or don't have the money to get their things out of where they were living. So this act helps provide a structure for that tenant to protect their personal property from being discarded, destroyed, or lost if they were evicted, or if they left a tenancy for some other reason, whether it's to avoid a domestic violence situation, or trying to get into subsidized housing. This act protects their right to their personal property, and for it to be protected if they were to leave or break a tenancy. So typically, this usually occurs within the eviction context, but sometimes it does occur when someone's just leaving the property because they need to break the lease. And a lot of the time that occurs when someone gets into a subsidized housing and they need to get in there as quickly as possible to not lose something such a vital form of housing for people.
Okay. All right. Very good. So it sounds like New Jersey is has really been very thoughtful and very very pro tenant. One of the common things or through lines that I hear is that New Jersey happens to be one of the most, if not the most, tenant friendly states. Is that something that you is your understanding or your opinion in your area of practice?
I mean, yes. I mean, I haven't practiced outside of New Jersey,
Mhm.
so I would
Fair
say
enough.
probably New York is a little different than New Jersey, and maybe just as tenant friendly. But not many states have a good cause requirement for eviction. A lot of the time, some states landlord doesn't want you there; they just file and they move forward with an eviction.
Wow. Wow.
So New Jersey is not one of the few. I don't know how many other jurisdictions include a good cause requirement, but New Jersey includes a good cause requirement for an eviction. Um, Now, that doesn't mean that we're totally tenant friendly. I think because there are laws governing tenancy, and these laws are less than easy to kind of interpret, remember, or understand for a tenant, pro se or otherwise, it's good to have legal counsel.
Mm.
Um,
Yeah.
so in that case, it's nice that you're doing this because it could kind of distill what a tenant may need to know if they are in a situation where, hey, I'm evicted, I have all my belongings back at my old apartment, I didn't have the money to get my stuff out. What do I do?
Right.
Um, so this act really helps a lot in protecting those possessions. I see here on the slide it mentions that landlords are supposed to store the property for a limited time. So what is that limited time?
Excellent. Yeah.
Basically,
Perfect. Yeah.
yeah. So basically, a tenant, when they are either removed from the property through an eviction, or if they leave and the landlord believes that the tenant is actually being, you know, abandoning the tenancy, the landlord has to notify the tenant that he needs to come back and get his things, or they will be discarded. So this notification has to be in writing. It has to be sent to the last known address of the tenant. Now, this seems a little odd, especially if the last known tenancy is that apartment.
Mhm.
So a lot of the time, mail forwarding is a thing. So tenants, if they're in this situation, should always have their mail forwarded.
Mhm.
Um, and to completely assure that they get this notice, they should leave a forwarding address to the landlord. Not only for the purposes of hopefully getting the security deposit back when they leave, but also
Right.
to get this notice about their possessions if they do leave things behind. Now, I don't want to get too ahead of myself, but there are certain requirements that has to be in that notice to the tenant from the landlord.
Sure.
But the main thing regarding the timeline is that within 33 days of receiving that notice, their stuff is going to be put out on the street.
Okay.
So, a tenant really has to respond once they receive that notice. And if they don't get that notice and they don't respond, then within 33 days, their stuff is gone.
Okay. So one thing I wanted to back up as we, kind of go through the slides, and I want to revisit notice more in depth with you, and that was an excellent recitation. I appreciate that because those are important numbers to know. But one of the questions I wanted to ask you is when the landlord says, they provide that notice that says, hey, like you left your stuff and I'm assuming it's going to be abandoned and you've got 33 days, to get it or otherwise it will be disposed of. In that time period before the landlord has the opportunity or the legal right to dispose of that property, where do they store it? Do they just leave it at the former residence or do they have to put it in a storage unit? How does that work?
So it could be in the residence,
Okay.
and it could be in a storage unit. It should be somewhere. It can't be left on the curb. It can't be left in out on the front lawn. It has to be somewhere where the actual possessions won't be damaged or lost,
Okay.
and they have to be kept safe. So it has to be in somewhere that the tenant can either visit or the landlord can give access to the tenant in order to pick up. So the apartment could be a good place. It could also be a storage unit. Now, the landlord is allowed to charge for the storage.
I see.
So
Okay.
the charge has to be reasonable in relation to other storage facilities within the area.
I see.
So he can't charge an exorbitant charge in order to kind of store these possessions. Moreover, they can't charge additional rent for the tenant to come back and pick up these possessions. That's one of the protections under the act, that
Gotcha.
the landlord can't charge a fee for the tenant to get his own stuff.
Gotcha.
He can charge for the storage of the stuff, but that can't be an impediment for the tenant to get it out. So
Okay.
it's basically, hey, landlord, we know it's an inconvenience and a cost to store these things. You are allowed to charge this, right, in a civil context, but the tenant has to be able, if they're going to come back and get it, has to be able to come back and get it without having to pay something to pick it up.
Okay, so what you're saying is that, let's say that storage, so they can't use the charge for the storage as leverage to, like, they can't like use it as a bargaining chip for the tenant to get their stuff back. They have the landlord has to allow the tenant to get their things, but as a
Mhm.
separate matter, if that charge remains unpaid, then the landlord could take them to like small claims or something like that.
Yep, exactly. They could take them to small claims, but they can't say, "Hey, if you don't pay this charge, we're not giving you your stuff."
Gotcha.
No, you have to be able to provide the tenant the opportunity to pick it up. And if you are, to maybe to make for the landlord to be made whole for the charges in storing those things, they could sue them in small claims for that storage. In addition to, if the tenant was behind in rent and that was the reason for the eviction, that could be added
Okay.
to the overall balance.
I see. I see. And what was I going to say? And okay, we'll just leave that at there for now. What about, so now, and just to go back to your point, when you were introducing the abandoned tenant property statute, you
Mhm,
had mentioned that this most commonly occurs in the context of eviction, but you don't have to be evicted in order
mhm.
for this property statute to apply.
Yes, that's correct.
Okay.
So, for example, a good example this might come up as is I mentioned, tenants leaving or breaking the lease for the purpose of trying to get into subsidized housing. There's no eviction complaint there. The tenant's actually breaking their lease to leave,
Hmm.
and they're trying to rush to get into subsidized housing because it became available. And if you don't, make the moves to get in there, you could lose your opportunity to maintain that subsidized housing. So, a tenant could use that, especially if the landlord thinks, hey, someone's just leaving. I don't know where they're going. They haven't mentioned anything. I haven't seen them on the property for months. What
Right.
happened?
Hmm.
Um, Landlord should send a letter to them saying, hey, I think you're out of there. You don't seem to be there. You have 33 days to pick up your stuff. If you don't, I'm going to throw it out. And, if the tenant's not responding, you lose your stuff.
Right.
So it would be a good idea, um, that the landlord not only send the notice, because if the tenant is still there and for some other reason, maybe they're in the hospital or something like that, that kind of confirms that they're still there.
Right.
Um, and number two, if they just start throwing their stuff out, even if they did vacate the apartment, there are damages the tenant can lodge against against the landlord
Okay.
for removing stuff when they did in fact leave, and that could be up to double damages of the fair market rate of any of the possessions lost, destroyed, or anything like that during that process.
I see.
So the purpose of the notices is to kind of smooth things out between the landlord and the tenant, especially when there's a miscommunication. It actually
Right.
forces communication to happen,
Right.
and that's a good thing. That's the purpose of the law.
Excellent. Okay. Well, that's great. That's good to know. And I appreciate you sharing that information with our audience. One thing I did want to ask about with regard to, as you know, because one of the things that we do as we go through the subject matter and navigating these slides is we do a little research here on our end as well, using the Legal Services of New Jersey manual as it pertains to the abandoned tenant property statute and other topics we've covered. But of course, tonight we're covering property retrieval. Now, this is there like a particular type of property that is protected under the statute? Is there certain things that are exempt from this protection?
Well, there's actually a bit of more time provided to mobile homes or manufactured homes.
Okay.
Um, Instead of 33 days, the tenant gets 78 days to actually remove their property.
Oh, okay.
Yeah, and I think that that is mostly because of a mobile home. There, a lot of the property that's owned by the landlord is actually just the plot of land and not the mobile home itself.
I see.
So, moving a mobile home is no small feat,
Mm,
especially if it's been there for years. So, a lot of the time, the tenant owns the mobile home or manufactured home that the plot sits on. So, that's why they're provided additional time in order to secure, the transportation or the other costs that are needed to secure to move the mobile home off the property. That's
interesting.
not only for the benefit for the landlord, the owner of the lot or plot of land, it's also a benefit for the tenant to secure that. The reason why for the landlord is, hey, you don't have to pay for the extra money to remove this thing off the lot if you have a tenant who's going to come in, incur the cost to do that himself.
Yeah.
So it kind of helps both parties in that
Right.
respect.
Great. Okay. All right. And we'll go ahead and just keep moving along as well. And one thing I did want to touch on with regard to, the items that can be, sold or, auctioned or
Mhm.
discarded versus those that can't. What about animals and pets? How does that work when people leave animals and pets behind at properties?
Well, the landlord could call animal control,
I see.
and that's something that I'm sure a tenant would not want to happen if you do value your pet. Mostly because there's two reasons why animal control is called. One, it's an animal. The
Mhm.
tenant has a responsibility to that animal, and if they just abandon it. Uh, that's not good for the animal, but it's not good for the tenant also because the
Right.
tenant could face possibly animal cruelty issues,
Right.
especially during the eviction process. If you're just leaving an animal there, police are involved in the eviction process. So it would behoove the tenant um, to make the proper moves to get the
Sure.
animal off. And if they abandon the animal, landlord can call animal control and remove the animal, and animal control would take it in. um, I do notice like food
Mhm.
can be removed because you don't want spoilization to happen during, the absence of someone in the property, especially if it's an apartment building. If you
Yeah.
have food that's just remaining there, you could cause an infestation of rodents and vermin, and that's not good for the other tenants that are remaining there.
Sure.
So the landlords do have the ability to remove food, and it doesn't apply to motor vehicles or any other vehicle on the lot that's remaining there. So a lot of tenants, in including having an apartment, also have a parking space. It doesn't include the parking space, so the landlord could remove the car off the lot.
Gotcha.
And that could be a safety thing for not providing the parking lot. It could also be a thing in terms of they don't want it to be a place where the tenant's actually living out of the car when they were already evicted. That's causing some kind of contention between the landlord. So
Makes sense.
you know vehicles should be removed as well.
I understand. Okay. All right. Well, that's good. Very helpful. Thank you, John. We'll go ahead and move on from this slide. I think we've covered everything that should be covered with regard to that particular slide and the information contained on it. What I did want to ask you though about it is,
Mhm.
and you may have covered this already, but if you could expand on it, or if you haven't covered it yet, maybe we can just touch on that now before we delve into the next topics, is the landlord responsible? So if in the course of preparing to store what is presumably abandoned property, or while that time frame is, that clock is ticking for the former tenant to collect their presumed abandoned property, and in the course of that, whether storing it or securing it, they damage some of the property, or it gets stolen or anything like that. Is the landlord then responsible for anything that happens to that property in this regard?
So it really depends. Like, that's a very lawyerly answer, but a lot of it is if they follow the letter of the law to the best of their ability and take proper care of possessions when they're moving it into storage, there is cover for the landlord under this in terms
Okay.
of liability. Um, as long as they provide proper notice, they store it in a safe and accessible place and notify the tenant, hey, this is where your stuff is. Um, you know, Please notify us when you're going to come and pick it up. Then liability will actually be um, covered here. Like
Mhm.
the landlord wouldn't be liable for any you know accidentally damaged or lost material. On the tenant side, though, the tenant, when they're leaving, they're being evicted, or they just have to leave and they're leaving their stuff because they couldn't afford everything to get it out. They can make a very detailed list of what's being left behind, take pictures of what's being left behind, and if possible, if you have receipts for any of the things that are being left behind when they were bought, you keep them, because if the landlord doesn't do what they're supposed to under the act, that will serve as a way to sue the landlord for the damages and loss of the possessions in a civil sense. So, um, landlord, take every opportunity to fulfill the requirements under the law. Your liability will be covered. Tenant, to make sure you're covered, and if the landlord does not actually follow the law, take pictures of the things being left behind, itemize them in a list, and then keep the receipts for all possible possessions to show to the court, hey, I lost all this stuff. This is how much it cost. This is the fair market value of it.
Mhm.
This is my number in order to be made whole.
And then you said that if there were some, like, if there was some deliberate, damage, if proved in court, or if there
Mhm.
was some negligence that amounted to a judgment in favor of the tenant, as you said, could sue up to, what was that? What was that number again?
It could sue up to double the
Double.
fair market value of the possessions.
Okay,
So,
so if go ahead.
like for instance, if they left a refrigerator, not in New Jersey, not many tenants bring their own fridge, but this is for an example.
Sure.
If a tenant bought a fridge, right, they didn't have a truck in order to get the fridge out when they were evicted. They could write to the landlord, hey, I'm not leaving this thing.
Mhm.
Right before they leave, I'm not leaving this thing. I'm going to come back, right? And they have to come back within 15 days of notifying the landlord, hey, I'm going to come back in 15 days. I'm going to pick this up, right? Or some other reasonable amount of time for them to come back. The landlord doesn't do that and just throws out the fridge. It would be a good idea before they left if they had a picture of the fridge to show the state of the fridge, the actual um, whether it's in working condition or not dented or anything like that, and then also a receipt showing how much the fridge was in order to file a complaint for the damage to throwing out the fridge.
Yeah.
Now, in that complaint, the tenant can sue for double the amount of the fridge under this act,
Right.
and that's an incentive for the landlord to say, hey, rather than just throw this out because you want to re-rent the apartment, um, maybe you should wait, because it would cost probably more than a month's rent um, for you to just throw this out. You're basically throwing money out by doing
Right.
that. So rather than do that, follow the letter of the law, notify the tenant, or provide the tenant time to come and pick it up. Um, than just throwing things out.
Yeah, no, that's excellent. That's excellent advice, and really a great example that helps, flesh out the material that we're talking about. And I appreciate you taking the time to help us learn and provide that example. That's really, really helpful and really good visual there. So what we have on the next slide, as we move through the material. So what I wanted to do, John, and I think you might be familiar with this letter or this form, because it is in the Legal Services of New Jersey landlord-tenant manual, the brick book, as you've referred to. And it's a form letter, a template for somebody a sample letter to protect your property under the abandoned tenant property state. So request to store property you are unable to remove. So what I wanted to just ask you about here is just kind of looking at this slide right here and see if, because what we were talking about before were things that you basically would recommend based on the example. So if you have a tenant, in your example, a prospective tenant who, they're leaving, they're breaking their lease, or they're going to be evicted, and they want to, they got to move out, right? But they're unable to collect all of their things before moving out, and they've got to come back for these things. So it sounds like you've said, take pictures of the property, whatever it is that you have to leave behind, itemize it, get receipts for it, some kind of valuation for it, make sure that you have a nice thorough account of the items that are left behind. But this, in addition to that, it looks like correspondence that is then sent in writing to the landlord, informing them, it seems like, proactively ahead of the landlord's notice of a presuming, abandoned property, and stating, hey, this is what I've left behind. It's your responsibility to maintain it per the Abandoned Tenant Property Act. And can we set up some time where I can come collect those things? Do you think, based on the language featured in this particular slide, do you think that this is sufficient correspondence to communicate that purpose?
I mean, it seems to, it comes straight from the brick book from
Sure.
Legal Services of New Jersey. It does provide space there. I would also provide, hey, in terms of a range, maybe propose an actual date that you want to come back, just to kind of, leave it out there for the landlord. Hey, I can come back on this day. It's more of an incentive for the landlord to try and, engage with the tenant, to say, hey, let's work this out, rather than, just throwing things out.
Right.
And, I do like the language here, saying, you're required to store my property pursuant to the Abandoned Property Act. I would just add that if they do store it somewhere, if it's not in the apartment, that they provide reasonable notice of where it is actually being stored if it's not there.
That's a great
It's
point.
being stored in a different place, at a storage facility, please let me know, as soon as it's moved over, or if it's going to be moved by a certain date, right? And let me know when that date is, because maybe I could come in before then. So
Okay.
maybe language in there saying, hey, if you're going to move this off site, please let me know when that's going to occur. And then B, once that occurs, tell me where it's going to be. Because if I'm not going to be able to be there to pick it up, I want to know where it is so I know where to go.
Right.
And I do like the phone number there and everything like that. I think another thing to be included in there is probably a forwarding address as well, so
Right.
that anything in writing to the tenant could be sent to them and they could contact them in writing via that way.
Excellent.
But I do like the phone number too.
Okay, very good. All right, very good. So, and what I want to ask you, as we're going through some of this material, and we're looking at some of these examples, and you're providing some of these hypotheticals and fact patterns. Is this something that you come across, rarely, or is it something that you see regularly in your practice in landlord-tenant court? I mean, and not necessarily the whether or not the client has sent a letter and what they've done. But I mean, do you see these issues often in your representation of clients where you see that their property was either, discarded, illegally, or, they're debating in court over their property? Is that something that you often come across?
Um, on occasion, I think what my relationship with the Abandoned Property Act has typically been is, especially since um, new uh, statutes have come out after after the pandemic, specifically the Truth in Renting Act, um, that have probably changed a bit of how this particular Abandoned Property Act is enforced. So, for instance, I did notice in there there was like a mention of an orderly removal. What an orderly removal is after a tenant receives a judgment for an eviction, what typically happens is that if they are still unable to pay off the back rent, still unable to get back in there in order to avoid an eviction, they could file for an orderly removal, which would give them an extension of 7 days to move out, get their
Sure.
things together to move out.
Mhm.
Um, After the Truth in Renting came out, there was a form for the orderly removal process. That form includes a proposed order for the orderly removal to be granted to the tenant that the judge fills out. In that proposed order, it actually states that you waive your right to the Abandoned Property Act,
Oh, wow.
right?
Wow.
So you get this 7 day orderly removal, and you're basically losing a statutory right to get your stuff if you don't have the money to come up with within 7 days. Now, that's a tough thing to give up for a
Yeah.
tenant.
That's crazy.
And
Yeah.
a thing that a big issue that comes up is, how am I going to come up with money within 7 days to get my stuff out,
Right.
right? Um, Now the theory is that that was included in the orderly removal because now there has been an extension of time in the eviction process itself, where the tenant should be getting ready to leave, right?
Right.
So prior to COVID, a landlord-tenant action, you're in court within a week or two after filing.
Mhm.
Now, statutorily, it's required once it's actually served on the tenant, it's a 3 to 4 week wait until you get a trial date. So the eviction process itself has lengthened.
Right.
However, this process to protect your right for any kind of abandoned property has been gone to the wayside a bit with this addition of the provision that you're waiving your right to the Abandoned Property Act. That's a problem.
Yeah.
I think especially when tenants are hard hit financially and they're getting into a situation where they're being evicted because they couldn't make rent. Um, you're without a hearing, without any kind of process where you're being advised of that you're waiving your right to the Abandoned Property Act, a lot of pro se tenants just sign this orderly removal. So because of that, they lose that right to the Abandoned Property Act.
Wow,
So
that's incredible. That's incredible.
that's a tough thing to lose. So
Absolutely.
what we try to do in settlement talks, if we know the tenant's not able to come up with the back rent, we try to build that in the settlements. Like, hey, this person has a bunch of stuff that you need to get removed off the property. The Abandoned Tenant Property Act does provide, housing of this stuff for up to 30 days. Rather than you expend the time and money to put this in a storage unit, give the tenant about 30 days to get this stuff together and get it out,
Gotcha.
um, and see if that can be done.
Yeah.
It benefits the landlord because they don't have to expend a cleanup crew to remove this stuff. And it benefits the tenant because they can get their possessions out there in time. I would argue, though, if the tenant is in a position where they may have agreed to this orderly removal, that they still file something in order to protect their possessions if they're unable to get it. One of the things they can do is, there is a motion you can file to require the landlord to hold their possessions according to the Abandoned Tenant Property Act. That would be in the small claims or special civil part. It would be an emergent motion. It would be something called an order to show cause.
Okay.
So an order to show cause would be, hey, I know I have this orderly removal. I want to file a motion in order to protect my stuff. I know I have to be out here in 7 days. I haven't been able to secure um, movers to get my stuff out. I want to use this Abandoned Property Tenant Act to protect my stuff. Please, judge, provide an order protecting my possessions in compliance with the Abandoned Tenant Property Act, so that the landlord isn't throwing my stuff out. And if he violates that order, then he's going to, potentially deal with me in small claims court
Mm,
for double damages of the fair market value of those possessions. And I think, if a tenant does that, knowing that they're not going to be able to get their stuff out, and that's filed in court, I think a landlord would probably think twice about throwing it out, number one. And number two, we'll try to work with the tenant in order to avoid the extra cost of hiring an attorney or
right.
going through court, losing time in order to, make sure to fight this motion.
Right.
So it would be a good idea for a tenant to file something like that, because it would be an incentive for the landlord to comply with the act and protect their
Absolutely.
possessions.
That's such excellent and unbelievably invaluable just advice right there that Jonathan gave to our audience right now. So I hope everyone's been paying attention to that, because that is a tremendous key component there. Because I think it's so important to say, as you said, with the pandemic having changed some of the rules, and someone files an order for orderly removal to stay on the property for an additional 7 days, but in doing so, they may have, given up their rights to under the abandoned tenant property statute. So having the opportunity, like a tool in order to show cause tool, which we've mentioned in our eviction only as it regards tenants video, you can file that, potentially, and then get in front of a judge to have them, provide an order from the court that allows you to have those protections. So really excellent advice, Jonathan. I hope I summarized that well enough. And that, I think that was really wonderful. And I appreciate you walking through that, because that's not mentioned in our slides. It's not mentioned in the LSNJ handbook, although it does talk about, the potential of losing your right if you, file the order for orderly removal.
Mhm.
But I think that's, excellent advice. Do you see in your experience, representing clients, because what I have seen or observed in the courtroom is that, tenants, often it's the landlord who has the money or the deep pockets, to, so to speak, to hire a private attorney to go through these steps or insulate themselves, from, appearing, or, at least, representing their rights more comprehensively. And it's usually tenants who either don't have the time to get to an attorney, don't have the money to get to a private attorney, or they're often bringing their case the day of to court, to legal services. So it's hard to give them the thorough, comprehensive representation they would have had earlier in the process. But do you find that tenants are, exercising these rights or asserting these rights and going through the procedure that you've outlined for us? Are they well informed enough to be able to do things like that? Or would you say that it most definitely requires an attorney?
I think it could be done by tenant if a tenant is told about it, right?
Right.
Um, we legal services, unfortunately can't take every case. I wish we could, and wish we had an army of legal services attorneys to do so. But not every case we can take, and there are certain priorities. The main priority is keeping people housed. That's the main priority for us.
Sure.
Um,
Sure.
from what I see, you know, I I don't see many of these cases regarding abandoned property, but they do happen. And sometimes when they do come to us eventually, it's too late. So let me go to an example. I did have a client when I was at CHOP who was illegally evicted. Illegally evicted. She was pressured out, um, and she was a disabled client on Section 8. She ended up in another housing, but she left a ton of personal property back in the former apartment.
Wow.
Primary thing she lost was durable medical equipment. something called the Hoyo lift. This person was paralyzed from the neck down
Oh my God.
and had a lift that their personal care assistant or home health aide used to bring them into the bathroom, place them in the bathtub, or use the toilet, and then lift them up and bring them back to the bed. Right?
Mm.
They lost that. That was thrown out. A Medicaid covered bed was thrown out. A number of other durable medical equipment, such as canes, scooters, motorized wheelchairs, were also all thrown out.
Goodness.
Right? So she came to us almost a year and a half after this happened.
Mm.
And one of the issues she was having was that she was filing this order of show cause to get this stuff back. She filed it maybe a couple months after, and then it's been matriculating through the court. And when she came to us at that point, a lot of that stuff was gone.
Oh.
So, you know, what I would say is the sooner a tenant who's either being forced out is either being evicted, as soon as you get court papers, just call legal services.
Yes,
Even if you
I
don't
agree.
qualify financially, at the very least, you can be forwarded to an attorney who could probably give you a consult for, little to no cost if you don't qualify financially for our services. But a lot of the time, tenants who are in that situation do qualify.
Yeah.
So you would at least get the legal advice that I'm giving right now on what you can do,
Right.
right? So either through the eviction process, or if you're already evicted, what you can do to make sure you have access to those possessions and you don't lose them, and what your rights are in there. So it happens. In terms of how often it happens with me or with my colleagues, I really can't say, because a lot of the time when we get these cases, we're right involved at the eviction stage,
Right.
and we're trying to build in time so they can get their stuff out as soon
Mm.
as possible along with themselves. Um, so it doesn't happen that often, but we do interact with this law itself and try to use the law to say, hey, I don't want to have to file all these things after this person is out because you're not willing to deal with me and give the tenant the time in
Mhm.
order to get their stuff out. Just work with me. If you're not, the tenant's not paying me, they're getting a free attorney. So I know what their rights are. I can file these litany of motions in order to do it. Landlord, a lot of the time, if they're pro se or hiring an attorney, they're going to spend time and money in order to protect against my motions. So it would behoove them to just work with the tenant.
Right. Yeah. Yeah.
And a lot of the time, working with a tenant would be less time expended to get that stuff out and less money than being totally obstinate and forcing the tenant out without the time
Yeah.
provided to get their things.
Excellent. Excellent. Really, I just really thank you so much, John. That is just really great information. That that example is heartbreaking. Just to hear someone suffering like that, and again, it just bolsters the point that you guys are really doing just such incredible work there. And thank goodness that there is such really excellent, well-rounded, wraparound, comprehensive legal counsel at Legal Services of Northwest Jersey. So really, thank you for providing that information and just expanding on some of these concepts that we're talking about, because it's not easy. You lay it out and outline it perfectly, but even the manual breaks it down quite nicely, because it's not like it's a law school textbook or you're reading case law or anything like that. But even then, as a layman like myself, you go cross-eyed reading this stuff and you're like, oh, 33 days or 30 days, whichever comes first. And you're like, well, wait a minute, if they're mailing it, isn't it delivered already? But what comes first? And you're just like, my nose starts bleeding. Like it's unbelievable. It's crazy. So again, it's just so appreciative of your advice, your acumen, your professionalism, and your opinion and fact patterns, experience. All of that here is so greatly appreciated. So while we've been talking, audience here, John has outlined some really, important information and provided some really great examples as to how the abandoned tenant property statute is applied and some of the nuances that are involved here. He did talk about notice that's required. So I'm just going to break down the slide that's up there here because I think I've already asked you about it. And I don't want to, send you through this circular, discussion about it, and we don't need to beat a dead horse. So I'll just quickly, touch the fine points here. So a landlord must give written notice to a former tenant if the landlord wants to dispose of property left by the tenant after he or she moved out. So again, the important thing is that written notice must be given to that former tenant. So the notice must be sent by certified mail, return receipt requested, or by receipted first-class mail addressed to the tenant at the tenant's last known address, as John had pointed out earlier, which may be the address of the premises and at any other address known to the landlord. So that's just something I wanted to make a point. And as you can see up on the slides there, again, the most important thing is that the landlord has to give written notice to the former tenant and that it needs to be sent either by certified mail or by receipted first-class mail addressed to the tenant at the tenant's last known address. And of course, that could be where they just previously resided or any known address that the landlord is aware of. But I think what's really helpful, as we touched on earlier, that note that is really proactive that a tenant can send to a landlord that says, hey, landlord, I don't have the time to remove all of this stuff, but it's protected under this statute. Here's where you can reach me, and providing a phone number or at least a forwarding address, I think is really sound advice as well. So that's really great. But as it pertains to the particulars of the notice, just to touch on these bullet points, the landlord considers, so the notice must state this, that the landlord considers the property left behind to be abandoned. The property must be removed within 30 days after delivery of the notice or within 33 days after the date of mailing, whichever comes first. If the property is a manufactured or mobile home, it must be removed within 75 days after the delivery of the notice or within 78 days after the date of mailing of the notice, whichever comes first. And Jonathan touched on that before, and the reasoning, the logic behind why there's more time awarded to manufactured and mobile homes, because, oftentimes what the landlord owns in those instances is the plot of land upon which the dwelling rests, that mobile home or that manufactured home. So it often takes a longer length of time, especially if a lot of time has passed, to then transport that particular home or dwelling off of that plot of land. So more time is given to those particular tenants as it pertains to property that is presumed abandoned. So, but typically in other instances, it's 33 days, as John had mentioned. You get 33 days once the landlord sends you that notice and they say, hey, this property is presumed abandoned if you do not collect it within 33 days after it has been mailed. Okay. And then the notice must also inform the former tenant that if the property is not removed, the landlord will sell it at a public or private sale or will dispose of or destroy the property if it has little or no value. John, that is one distinction I wanted to ask you about. With regard to whether the landlord has a choice to dispose of or sell it or auction it at a private or public sale, how do they delineate or distinguish between what can be disposed of and what can be sold? Because it says if it has value, or it can be disposed of if it has little or no value. So is there any kind of controlling case law or statutes, or what is the distinction or the delineation between property that has value that can be sold and that has little or no value that can be destroyed?
I think it really depends on the context of the actual issue at hand. So I don't know of any case law off the top of my head, but practically speaking, I think one of the main things that can delineate something that is of value and something that isn't is, just looking at the actual object itself, a fridge or any type of appliance itself that isn't owned by the landlord, I think could be sold for something of value. Same thing as, piece of jewelry, um, things that, practically speaking, you look at, hey, I can sell that for something.
Mhm.
Um, things like clothing, things of sentimental value that, really can't be resold, like, stuffed animals, for example, is one thing that
Right.
comes to mind. Pictures, um, things like that. Those typically can't be sold for anything of value, so that could be tossed,
I see.
right?
I see.
But the tenant might value them at some point. So, that's why I think the public or private auction is put there. Um, and I think it's also kind of put there too that, if for some reason the tenant isn't actually is notified, but somehow forgot, something happened where they didn't respond, they at least have the public private auction as an option to go and get their stuff,
Yep.
right?
Mhm.
They know where it's going to be. The other option is, the order show cause I mentioned earlier. But I don't know of any offhand case law that kind of delineates, what is subject to the auction and what really
Well,
shouldn't.
sure.
I
And
think it's more of like practical stuff.
yeah, and even in lieu of that, applicable case law, if there exists any, controlling or binding case law that speaks to that actual topic with, regard to the abandoned tenant property statute. But the logic that you've laid out for us, makes it clear in understanding that, here's how you can, decipher, or the landlord would decipher between that which has value versus that which is not really resellable. And then you mentioned that, now what I wanted to ask about when they sell this property, um, you know, because there is property that certainly has value and is sellable. What like happens in that instance? So does the landlord get to recoup money from that? Do they get to keep the money that results from the sale of that particular property?
I believe they can. I think that's the purpose of defraying the cost of storage and possibly, any back rent that they didn't pay.
Gotcha.
um, they can use that to lower the balance the tenant has with with the landlord. So, but if the landlord then sues for, the back rent or for the storage costs, they have to account for that.
I gotcha.
Not doing so would be, number one, it would be lying to the court, but it would also be engaging in unclean hands. It's like, hey, I sold your stuff. It covered, the storage costs and everything. Shouldn't sue him for that,
Right. Right.
for the storage.
Yeah.
But the thought is too, they should also be notifying the tenant, hey, your stuff is still here. Are you going to pick it up or not? And that's the purpose
Gotcha.
of the law.
Okay. Very good. Okay. So now let's assume that, as you can see by one of our last few slides here, that the tenant has received the notice, because we've talked about, when the landlord, or excuse me, when the tenant leaves and they've either proactively said that, hey, this is I can't get this stuff, but here's my letter saying that you got to hold on to it for me, and let's arrange for a time to get together when I can get that stuff out of the place. And should you need to get in touch with me, here's my contact information. And then, of course, we've talked about like what the notice requires and things like that. But John, can you walk us through what happens then once the tenant receives the notice that the landlord has provided them with that written notice that we covered in the last slide that says, hey, if you don't retrieve your property in 33 days, it's going to be destroyed or sold or auctioned at a private or public auction. What is the tenant's next step when they receive that notice from the landlord that says, hey, I've got 33 days before my stuff gets tossed? What can they do in that instance?
So they should definitely respond in writing. Um,
Okay.
First thing, calling the landlord would be a good idea, having a verbal conversation. But should always follow that up in writing,
Mhm.
confirming that they're not abandoning those possessions and that they want to set up a time to come back, right? Under the statute, it's within 15 days of them responding that they could come and retrieve their belongings. So, for example, if someone um, received a letter 33 days, right, after the date of the letter notifying them, hey, you left some stuff, they get 15 days from from receiving that letter by the landlord to come back and get their stuff, right? So it could kind of extend the deadline a bit to
Mhm.
take into account, mailing and things of that nature.
Excellent.
Second thing in that letter, in terms of responding that you're not abandoning it and you want to set up time to come in within those 15 days,
Mhm.
is providing an address and a telephone number for the landlord to get in touch with the tenant, letting them know, hey, I'm available. Please make arrangements with me so I can pick up my stuff.
Sure.
Um, and I think the benefit of having that in writing is not only to communication with the landlord and confirm what you were discussing over the phone with them if you called them first.
Mhm.
It's also having something in writing that you can keep a copy of in order to show to court if the landlord then violates
Right. Right.
the statute. So you have something showing, hey, I sent this letter to the landlord when I got his letter by certified mail. Always should send it by certified mail and regular mail. Because in the state of New Jersey, sending something by certified mail and regular mail is considered service in a
Oh,
legal
okay.
context. So if you do that and you have confirmation that the landlord received it, you can show it to the court. Say, hey, I did notify the landlord I was going to come back and get it. I called him. I sent him this letter by certified mail and regular mail. And for good measure, you should send it by email too and provide it to the court. I notified him and he still threw my stuff out or he
Wow.
still sold my stuff
Right.
at a public auction. So you can show to the court, hey, I did provide the requirements and notifying the landlord. I did want to get my stuff and he still violated that. It's a protection for the tenant in order to do that. So it's always good to respond in writing once they receive a letter like that from the landlord.
Very good. Very good. And in the event that there is a violation by the landlord of the abandoned tenant property statute, if there is that violation, they have the opportunity to file like a claim in court, right? And you said for double the fair market value of the property
Exactly.
that was disposed of.
Yeah, double the fair market value. Or if let's say the tenant sends this and hasn't received any response, they could also file an order to show cause to hopefully restrain the landlord from throwing out or auctioning off any of the remaining property.
Okay, there you
So
go. Yeah.
so if you're within a close proximity of it, either being notified from the landlord or from the actual eviction, you can file that order show cause. So the order show cause I'm talking about is called the order show cause for return of personal property and restraints. So you're basically saying, hey, judge, I'm asking the landlord to show cause why he should throw my stuff out. I want a hearing on this, right? And while we're waiting for the hearing to be scheduled, I want the court to restrain him from throwing my stuff out or continuing to throw my stuff out. That gives the tenant the opportunity to hopefully know where his stuff is, make sure that it remains there, and have the court restrain the landlord from further violating the Abandoned Property Act,
Sure.
and have a hearing to make sure, hey, is all my stuff accounted for? And if it's not, then you're kind of building the case to file small claims or law division case if the added fair market value times two is more than $15,000. And in my example I gave before, that's the durable medical equipment could far exceed that.
Wow.
It could
Yes.
become a law division case, and the landlord could have a huge problem if they're not following the act. And using the due process within the courts for the tenant and having these tools available, it could help the tenant a lot
For sure.
and maintain valuable things that they need either for their health or they have sentimental value with.
Okay, perfect. All right, well, we'll just go ahead and move on. So, John, just want to get your thoughts again. So, This is taken again directly from that chapter that deals with the abandoned tenant property statute. So this sample letter is responding to a landlord's notice about abandoned property. So if you want to take a look at the language up there, and this slide is literally the letter that is the sample letter that the handbook suggests as a response to the landlord's notice about abandoned property. Do you think that this is again sufficient in communicating effectively the needs of the tenant? And is there anything that you would add as we've discussed?
I mean, what I would add is definitely add a list of the things, right, that
Oh, excellent. Yeah.
that are left behind.
Mhm.
Um, and then in terms of the 15 days, I think that's statutory within there. I think that's a good thing to include. If you have an email, include the email as well.
Mhm.
And if you want to add a proposed date that to get the landlord to start a discussion to actually set up the time, that would be a good idea as well. But I think this is sufficient enough, except for I would include a list. Hey, these are all the things I left behind.
Sure.
Just putting the landlord on notice. Hey, if there's anything missing here, we're going to have a problem.
Right.
So I would think starting a list there would be a good idea for the benefit of both parties.
Very good. Okay. So let's go ahead over to our next slide. So, and this is our final slide for the evening as we come to the conclusion of the chapter. John, we're not going to get into the agent for service of process and things like that. We don't want to get too pedantic and convoluted about it. But we want to at least just touch on, again, what we've probably already brought up during the course of our discussion. But I would think it would be great to just kind of cap off here and ask you these questions. So I guess we already talked about it. So, and we'll just go through it. So if the former tenant returns to recover his property, the landlord must take the property available for removal by the tenant without payment of any unpaid rent. And John, you had mentioned that earlier, that you can't barter or bargain or say you can't, get your stuff back until you've paid me that unpaid rent. And if they have to put it in storage, or anything like that, they cannot also use any fees incurred for storing your property as a bargaining chip or leverage for, getting you to pay for those fees in exchange for your property. They have to give you your property back. And then if those fees went unpaid, they can then take you to court for it, for those fees paid. And then, of course, just want to read this portion of the LSNJ manual, and I'm sure the slides speak to it as well. If the landlord sells the property, the landlord may deduct the reasonable costs of notice of the sale, storage, and any unpaid rent and charges not covered by your security deposit. But must give any remainder to you with an itemized accounting. So again, as we said, that he or she, your landlord, can take and sell the property, and all of the cost of notice, putting, the advertising the sale, the cost of the storage unit, any unpaid rent and charges that aren't covered by the security deposit, they can then use whatever the proceeds for that sale, they can deduct that from the cost of getting that all together. And then I suppose if there's anything left over, that is due to the tenant, but everything else should be deducted. And I think we covered that already. And then finally, if the landlord fails to comply with any of the provisions of the abandoned tenant property law, you may sue for twice the actual damages. This means that you may sue for twice the fair market value of the property disposed of by the landlord, which again, we've reiterated several times. So and everything that you see up here on these slides, we've talked about through the course of our discussion already. So the landlord may store the tenant's property and charge for the costs. So we already know about that. The tenant fails to respond to show or move the property, the landlord may sell it. We already know about that. And then, of course, how they can deduct those the proceeds from the sale from the costs. But of course, if there's any balance left over, that is due to the former tenant. And then, of course, any adherence or any violation of the provisions of the abandoned tenant property law that gives the tenant or the former tenant the right to sue for double or twice the fair market value of the property that was improperly or erroneously or illegally or illicitly disposed of by the landlord. So that pretty much caps off our topics for this evening. And then, of course, we always end with a really insightful and wonderful quote. Dawn Hendershot, my colleague, our HR manager, our development team manager, our community outreach manager, our LIHEAP manager. She wears many hats and she puts these slides together for us and she does a wonderful job. And at the end, she always has these lovely quotes. So the power of finding beauty in the humblest things makes home happy and life lovely. I think that's a wonderful quote. And she always has these endearing phrases that allow us to realize, why it's so important and why we have these classes, why we, have these wonderful services like legal services, because, your home it's so important to have that roof over your head. And it's so important to know your rights and assert those rights because of what the implications are. And that this is where you live your life and where you deserve to have those rights and enjoy that happiness with your family as an individual, as a human being. So that's why it's so important, why we convey this information to tenants, but also to landlords as well, so that you are well informed and you can go ahead and have those transactions with your tenants and be have them more civil, have them be more peaceable, and make sure that you honor the rights that your tenants have. And likewise, tenants, so that you know what you're getting into when you sign a lease, when you engage with your landlord, and should it dissolve and become a litigious matter, you have those rights available to you and you're aware of what they are. But regardless of what you learn in this class, again, one of the most important things that I want to communicate, as John had mentioned, and I will say over and over again in any of our classes, regardless or irrespective of the subject matter that we're discussing, is get to a lawyer early. And as John said, even if you don't financially qualify for legal services, you could be referred to an attorney that is at a low cost, at the very least, a consultation that can give you the advice that you've been getting from John and other legal professionals throughout this series, on this platform. So please make sure, one, communicate with your landlord, communicate early, communicate often. And then, of course, make sure if you need it, legal representation before it gets to court. Make sure you get there early so that they can help you, give you that comprehensive wraparound counsel that you deserve. So again, I want to thank Jonathan Tolentino from Legal Services of Northwest Jersey for taking the time out of his busy day, his busy evening. I know he's got kiddos running back and forth in the background, so he's a busy guy, got his hands full. But thank you again for that lovely presentation. Such a thoughtful, considerate, thorough recitation of your knowledge and the examples, and helping us understand, all these, really complicated facets, and breaking it down for us and giving us that great information. So thank you to your time and everything that you do at Legal Services. You guys are absolutely wonderful. Thank you again, Jonathan.
Thanks, Frank, and thank you for having me. I think the most important thing I would like to echo from you is definitely get involved with an attorney, whether it be a consult if you don't qualify for services, but if you do, give us a call. All the information I provided through this this wonderful class is helpful. It directs you to the right place, but it may not exactly apply to your situation. That's why it's always good to involve to give us a call, because your facts, the context that you have in terms of the problems you're facing might be unique in a way that we need to know what's going on in order to actually apply the law in your case. So it's always good to get either us or a private attorney involved as soon as possible.
Excellent. Yeah, great point. And really just again, the through line that we are making sure that we communicate here is how important it is. So again, really excellent job. Really just a great class, wonderful episode. Thank you, Jonathan. Thank you to Legal Services. And thank you to the New Jersey State Bar Foundation again for your support and the funding that allowed us to present this material. So I hope everybody enjoyed it as much as Jonathan and I enjoyed presenting it to you. And we look forward to next week's class. That will be, I believe, on the, the 12th. Next week, Tuesday, the 12th, we'll be having David Saltzman again from Legal Services joining us. And we're going to be discussing boarding houses and mobile homes and your rights with regard to the eviction process there. So looking forward to it, continuing our STEP class. Thank you again for joining us this evening and have a wonderful night. Thanks again. We'll see you soon. And good night, John. Take care now.
Good night. Take it easy.
See ya.